the human is denied every day to hundreds of millions of people.
Dans ce temple des Nations Unies, nous sommes les gardiens d'un idéal. Nous sommes les gardiens d'une conscience. La lourde responsabilité et l'immense honneur qui sont les nôtres doivent nous conduire à donner la priorité au désarmement dans la paix.
We've got some difficult days ahead, but it really doesn't matter with me now because I've been to the mountaintop.
Chaque génération, sans doute, se croit vouée à refaire le monde. La mienne sait pourtant qu'elle ne le refera pas. Mais sa tâche est peut-être plus grande. Elle consiste à empêcher que le monde se défasse.
Bonjour à tous et bienvenue pour cette deuxième journée de notre Masterclass Global Actors for Peace. Alors, c'est un immense honneur et plaisir pour moi d'accueillir une invitée très spéciale à notre cœur, au mien aussi, même si on ne se connaissait pas avant, Anna Peters, donc directrice de l'Institut Max Planck d'Heidelberg de droit international et comparé, pour cette deuxième séance de la journée. Valentina Volpe va présenter un peu plus les travaux, les orientations de la journée et le profil naturellement du professeur qui nous accompagne. De mon côté, je ne vais pas répéter ce que j'ai dit hier, mais je voudrais juste insister sur un élément que j'ai passé de manière relativement rapide hier. Vous savez qu'à la faculté de droit, nous avons un centre de recherche, c'est le centre de recherche sur la relation entre le risque et le droit. Et dans le cadre de ce centre de recherche, il y a 4 thématiques principales, parmi lesquelles nous trouvons celle de la sécurité et des risques sécuritaires. En réalité, dans cette thématique bien particulière, il y a un lien très fort qui s'opère avec les 4 éditions de nos masterclass, et en particulier cette 4e édition. Et je pense que nous avons aujourd'hui la chance d'avoir à nos côtés un professeur de droit international qui a une expertise, je dirais, sans commune mesure sur un certain nombre de questions que nous nous posons depuis quelques années et sur lesquelles nous avons l'ambition d'apporter quelques réponses, en tout cas sur les thématiques qui sont proches des peace studies aujourd'hui et cette semaine. Voilà, c'était important pour moi de faire ce petit rappel et de dire que cette journée sera surtout une journée juridique par rapport à la journée d'hier, mais que nous maintenons le cap tout le long de cette semaine sur ce dialogue qui a commencé à s'opérer entre droit et sciences politiques. Et la conclusion pour ceux qui étaient restés et qui, justement, espionnaient un tout petit peu ce que nous avons pu dire hier en conclusion entre nous, c'est que nous souhaitons de manière beaucoup plus forte faire encore plus dialoguer les 2 disciplines qui sont des disciplines cousines, si ce n'est des disciplines jumelles. Et là, c'est une ambition que nous ferons réalité dès l'année prochaine. Voilà. Alors, Valentina et Sonia, je vous laisse la main pour la suite. Et encore une fois, un grand merci, professeur Peters, d'être avec nous pour cette conférence aujourd'hui.
Merci Ioannis, and merci Professor Anne Peters for being with us today. This is the second day of our masterclass, and as Ioannis said, is the more legal one, is the English-speaking one. And it's really a great pleasure for me to welcome Anne Peters today virtually in Lille in our Masterclass Global Actors for Peace Beyond the West and the Rest. This has been a long-awaited lecture that it's since a few years we try to organize and arrange, so it's a particular pleasure that even virtually we can have Anne with us today. I will just say a few introductory words to Anne. Anne is director at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and she is as well one of the most renewed international law professors. Today, she's professor in the University of Heidelberg, Freie Universität in Berlin, Basel, Switzerland, and as well global law professor at the University of Michigan. Part to her academic expertise, she also has a great international legal expertise. She has been a substitute member of the Venice Commission. She has been legal expert for the Independent International Fact Findings Mission on the conflict in Georgia, president of the European Society of International Law between 2010 and 2012, since 2019, chairwoman of the German Society of International Law. In 2020, she has been awarded of a doctorate honoris causa with the following motivation that I think really grasped very well Anne's background and contribution to contemporary international scholarship. C'est en français. À la brillante internationaliste qui mène une réflexion essentielle et novatrice sur la gouvernance mondiale, à l'éminente constitutionnaliste dont la pensée s'inscrit dans une perspective globale et à l'humaniste qui promeut le statut de l'individu en droit international tout en ouvrant à la fondation d'un droit mondial des animaux. I really think that this laudatio grasp all the intensity and richness of the academic profile of Anne Peters, who not only has an incredibly broad research interest, including constitutionalization, history of international law, global animal rights, global governance, the status of humans in international law, but she really contributed to the creation of totally new fields of international law. I think about global animal law, I think about global constitutionalism. That is really the topic and that we would like to deepen with her today. And on a more personal note, I would like also to share the fact that I had the pleasure of working with, under the guidance of Anne Peters during 3 years of my life, during my PhD in Heidelberg. And I can tell you that she's one of the most brilliant and inspiring scholars and women you can have the chance of meeting on your parcours. And I think it's really wonderful to share her experience, her knowledge with you all, with my students, with our students today. So Anne, thanks a lot for being with us today. And of course, you have the floor.
Merci beaucoup, Valentina. Maintenant, c'est très difficile de commencer un cours après ça. I think this was the most flattering and exaggerated introduction I ever got. So let's immediately move to the substance. Global constitutionalism, what's left? Is there anything left? Especially in times of pandemic. We are really going through difficult times. As you all see, there is a backlash against international law, against international institutions, and against global constitutionalism as an underlying idea. Just some recent incidents. The European Court of Human Rights issued a judgment in December, shortly before Christmas, in the case of Demirtas against Turkey, about the ongoing deprivation of a member of the opposition. Turkey was found responsible of violating various convention rights, and immediately the president declared that the judgment was non-binding, that Turkey would not follow the judgment, and there was also a large-scale cyber attack on the website of the Strasbourg court. That was over Christmas. Then, directly after Christmas, 6th January, as you know, the mob entered the US-American Senate on Capitol Hill to disturb violently the confirmation of the presidential elections. 5 people were killed. Moscow immediately then said, well, the United States can no longer prescribe the cause and have lost any entitlement to say what's about democracy. And in Beijing, the Speaker of the Foreign Affairs Department drew a parallel to the pro-democratic protests in Hong Kong and just showed videos comparing the rush on the Senate with the rush of protesters in the Legislative Council in Hong Kong. And then around these days, 40 activists and former parliamentarians in Hong Kong have been sentenced to long prison sentences. At the same time, the European Union signed a trade agreement with China in which China does not commit to terminate forced labor, but only promises to work towards abolishing forced labor. Another incident, the final example, Putin already last year, the Russian President Putin said at the eve of the G20 summit that liberalism is obsolete, says Putin. So what are the reasons for all this backlash now? Several factors seem to play together. First, I think there is disillusionment with international law. International law seems to exist on paper without sufficient attention to realizing the principles. Second, there is a repulse against what's called double standards and hypocrisy of the West. Third, there is a globalization fatigue because the wealth trickle-down effects through trade liberalization and foreign investment have not reached everyone, have not reached the most poor and abject. Material inequality of wealth and income is rising inside states. And the poorer classes in the wealthy states have not benefited much from globalization, but rather feel threatened by it. Fifth, and for me most troubling, is the fact that the backlash is in line with the shift of political and economic power in the world. States that have traditionally applied a top-down governance style and which lack a deeply rooted rule of law and democratic tradition are on the rise. And besides, even traditional democracies are eroding from the inside, as we just saw in the US. And this overlaps with the power gain of states, which build more on collectivist, one could even say anti-individualist traditions, or religious non-secular traditions, or even religious fundamentalism. And for me, as a legal scholar, the most sobering observation is that the international legal order and what we called global constitutionalism around the turn of the millennium is in decline at the same time as this power shift is occurring. This parallelism might be a coincidence, but it might also show that the law is only an epiphenomenon to politics and the economy. When the spheres of politics and economy change, then the law seems to simply follow. It is a truism now to speak of the decline of the West and the rise of Asia, visible in the Chinese Road and Belt Initiative, the so-called New Silk Road, which already kind of engages 60% of the world population. Also, some new institutions and regional arrangements have been erected. For example, the Asian Infrastructure and Investment Bank of 2015. And I already mentioned the very new Chinese-European trade agreement, which still has to be ratified, of course. In the COVID crisis, the United States have the world record in absolute terms of fatalities through COVID. This reached, as you know now, the threshold of over 350,000 deaths, whereas China officially reports only 5,000 COVID fatalities, which is 60 times lower than in the United States. I have my doubts about the Chinese figures, but the factor of 60 still tells something, even if it's not probably fully correct. So what does all this mean, and what can the concept of global constitutionalism still mean in the current constellation? So first of all, I would like to explain a little bit what I mean by global constitutionalism. That is an intellectual movement, a movement which both identified some features and some functions of international law in its interplay with domestic law as being constitution-like or even constitutionalist. So that was a type of positive analysis. But the intellectual movement of global constitutionalism also seeks to provide some arguments, or sought to provide some arguments, for the further development of these features in a specific direction. And these constitutionalist features and elements visible also in international law are the rule of law, of course, the containment of political and possibly also of economic power through checks and balances, the protection of fundamental human rights, the idea of accountability, the principle of democracy or of proxies for democracy, such as participation, inclusion, deliberation, and transparency. And finally, the principle of solidarity, fraternité, to mention in French, in France, speaking in France. Another key term is the word constitutionalization as a process or evolution from an international order based purely on principles such as state sovereignty, territorial integrity, and consensualism to an international order which acknowledges and has creatively appropriated and also modified principles and institutions and procedures which belong to the reservoir of constitutionalism. Constitutionalism covers both international law and domestic law, so it is invariably a multi-level phenomenon, one could say. And the various levels of law and governance might also compensate for each other's deficiencies, and that's what I called compensatory constitutionalism. The idea of constitutionalism and of a constitutionalization as a process first appeared in the law of international organizations. The founding documents of international organizations have long been understood to be both treaties and constitutions at the same time. The International Court of Justice described the hybridity of these documents as follows. I quote the ICJ now. From a formal standpoint, the constituent instruments of international organizations are multilateral treaties. But the constituent instruments of international organizations are also treaties of a particular type with a character which is conventional and at the same time institutional. So this is the dual nature of the founding treaties of international organizations. But beyond this dual nature, what else is meant and covered by what has been called constitutionalization? There is wide disagreement and there are wide differences with regard to different international organizations, starting with the European Union and then moving on to the World Trade Organization and to the United Nations. I now only very briefly want to say some words on the United Nations and the talk about or the diagnosis of a constitutionalization of the United Nations, of the World Organization. Here, the Security Council is in the center of attention. And the Security Council's power to impose binding measures has basically been exercised only after 1991, when the socialist bloc crumbled and when the P5 stopped blocking each other. And there the Council's power materialized. And it adopted sanctions, and this triggered the demand for, in fact, checking the Council's powers. And in this context, rule of law language emerged. For example, when the criminal tribunal for the former Yugoslavia was set up by the Security Council, in the famous first decision, the appellant Tadic, he challenged the tribunal and said that it was not duly created by law because the Security Council resolution, which was the basis, was not an international treaty. And in order to refute the interlocutory appeal on jurisdiction, the appeals chamber resorted to constitutional arguments. And that was actually under the guidance of an eminent, now deceased colleague, Antonio Cassese. The tribunal said, well, the Security Council is not legibus solutus, not unbound by law, but on the contrary, bound by international law and bound by the Charter, and therefore, then with various arguments, the tribunal said the tribunal has been lawfully and dutifully established. Another point of discussion were the Security Council's comprehensive sanctions, for the first time comprehensively imposed on Iraq in 1991, which lasted 12 years until 2003. And these comprehensive sanctions affected the social rights of the Iraqi population and really caused human suffering and fueled the insight that this was problematic and this could not be a solution. And therefore, then the Security Council shifted to targeted sanctions against individual people, which caused other problems then. These targeted sanctions against terror suspects and against illegitimate political leaders, which was designed to avoid the large-scale human rights problems, these targeted sanctions then risked to infringe procedural fundamental rights of the targeted persons and deprive them of judicial review. And this gave rise to a constitutional confrontation between the United Nations, the Security Council on the one hand, and the European Union and the Council of Europe on the other hand. And both sides, also the courts, the European Court of Justice and the European Court of Human Rights, they insisted upon upholding their regional human rights standards for protecting the targeted persons. And both European courts' principal justification was the assertion of a European constitutional order which mandated that the European courts must scrutinize the conformity of the regulations which implemented the United Nations targeted sanctions. For example, last famous judgment, the Aldo Limi judgment of the Strasbourg Court. So that's a bit about the historical debate with regard to the United Nations. And now I want to say some words about the principles of constitutionalism, which are now under attack and under erosion. Let's start with the rule of law. We here see a backlash in form of non-compliance with judgments of the international courts, notably the Strasbourg Court. And there is also generally skepticism against dispute settlement with courts and tribunals, as opposed to purely diplomatic negotiations. I mentioned the Turkish claim that the judgments of the Strasbourg Court will not be followed, that they're not binding. But that's not the only incident. Valentina Volpe and myself, we have worked on the Italian Constitutional Court's judgment of 2014, Sentenza 238 of the year 2014, in which the Constitutional Court of Italy says, or basically comes to the result that a judgment by the International Court of Justice on state immunity cannot have any effects in the Italian constitutional order because fundamental rights against access to judicial review stand against that. The Russian Constitutional Court has resisted the European Court of Human Rights, and a law in Russia has adopted a kind of a blocking of European court judgments if they infringe Russian sovereignty or the Russian constitution. And on a world level, of course, the most famous case is China not recognizing the arbitral award in the South Chinese Sea arbitration between China and Philippines. So this is the backlash against international courts, which strikes at the core of the international rule of law. The second big issue is the critique of international human rights. There are not only, as we all know, ongoing violations of human rights, which remain unsanctioned, but there is also now a very strong theoretical critique in all ideational camps, ranging from neo-Marxism to neoliberalism and conservative originalism. Some of you may know that in the United States, under the Trump administration, a presidential commission had been established, which is a commission on unalienable rights. This commission published a report in which it proposed to focus on the really most important human rights, for example, not social rights, and in which it proposed to cut back human rights to their roots. On the other hand, China proclaims human rights with Chinese characteristics. And in practice, China is very active, for example, in the Human Rights Council to secure the election of members of that body, which are favorable to China, which never criticize China, which praise China all the time. This has been called a system of proxy votes. In the inter-American system of human rights, in the Commission and the Court, there is a funding crisis, and domestic courts in Latin America have also resisted judgments of the Inter-American Court of Human Rights. So this was the second cluster, human rights. Third cluster, international organizations, the institutions of the international legal order. There is a movement of withdrawal from membership. That is, of course, not illegal. Each state is free to withdraw, but it tells us something. As you know, the United States left the Paris Agreement. That was possible 3 years after the agreement went into force. The withdrawal took effect in November 2020. The new president has announced to come back to Paris, but that still has to happen. The United States also terminated membership in UNESCO and also withdrew from the United Nations Relief and Works Agency for Palestine. They also withdrew from the Iran nuclear deal, which was a soft law arrangement. Other states, for example, Venezuela, left the Organization of American States. And there is also, short of going out from organizations, generally a legitimate crisis. Oh, and I didn't even mention the most prominent withdrawal, of course, the Brexit, which is in force since 1st January this year. Other moves are critiques and suspension of funding. For example, the United States terminated the funding, the membership fees, which is quarter of the budget of the compulsory budget of the World Health Organization, with the allegation of mismanagement, accusal of overly Chinese influence on the World Health Organization. The International Criminal Court is also under attack. Various African states refused to surrender the Sudanese President al-Bashir to the International Criminal Court. And this was justified by the African Union, I quote, because of ill-considered self-serving decisions of the ICC and, I quote, double standards that become evident from the investigations, prosecutions, and decisions by the ICC relating to situations in Africa. So there is the reproach of neocolonialism, of a bias against Africa. And there has recently also been issued a report on the performance of the ICC, which speaks of bad performance, but I have not analyzed this report in detail. As you know, most important states, or many important states, are not party to the ICC: United States, Russia, China, Israel, Syria. Therefore, there is some imbalance, you could say. 2 states have denounced the statute of the International Criminal Court. Burundi and Philippines have denounced. And the United States has issued sanctions against the International Criminal Court when it started to investigate possible war crimes of US American soldiers in Afghanistan. There are now sanctions against the prosecutor and other persons in form of travel bans. So no visa for traveling to the US, and blocking of money, freezing of money. Next to the International Criminal Court, let's move to the WTO, to the World Trade Organization. Here we have a crisis of the dispute settlement body because the US-American administration again reproached the WTO appellate body of going ultra vires and refused to participate in the appointment of members of the appellate body. And this led to a petering out of this body because it cannot work anymore because there are now only 1 member left or so. But, and also the WTO is in a way sidelined by more regional agreements, trade agreements. For example, there is a United States-Mexico-Canada agreement. China has launched a regional comprehensive economic partnership, which is the biggest free trade union in the world. And there are other important regional agreements, for example, the trade and investment, the Comprehensive Economic and Trade Agreement between EU and Canada, CETA, which is provisionally in force. A related area is the investment protection system. There is a specific critique against investor-state arbitration, which is criticized as being imbalanced because there are lots of obligations on host states, but few, if any, obligations imposed on investors. The system of various arbitral tribunals is also unpredictable in a way. It grants little legal security because there is not one centralized court and no system of precedence. The arbitrators sometimes are criticized that they are not fully independent, and the whole system, a proceeding, is also extremely costly. What I find a bit annoying is that the critique came from Western states. Let's take the example of Germany, only when Germany was sued by the firm Vattenfall. Then all of a sudden it found that the arbitration system is not necessary, actually, because there are well-functioning courts in Germany. But also the fact that the arbitration system functioned, that the tribunals rendered awards and imposed high damages, was a problem. For example, Argentina was in total, in the follow-up of the financial crisis and so on, condemned for awards in the amount of $667 million US. And now there has been a settlement on outstanding awards, which still leave Argentina with $500 million US of damages to pay. Not only Latin American states, but mostly Colombia, 19 million, Venezuela, 8.4 million, but also Spain had to pay 64 million euro to a Dutch solar and wind corporation company. In the context of all this, now, meanwhile, 3 states have denounced the ICSID Convention, the International Center on the Settlement of Investment Disputes: Bolivia, Ecuador, and Venezuela. Other states have revised the bilateral investment treaties they have. For example, South Africa, India, and Indonesia have either terminated certain treaties or they have gone through a revision process. So far about the economic law sphere. Now let's go to the use of force, the prohibition on the use of force, which is a core principle of international law. The prohibition to use military force has been blatantly violated in numerous cases recently, with weak or no sanctions following. Russia unlawfully annexed the peninsula of Crimea and thereby also violated the principle of territorial integrity of Ukraine in 2014. The United Nations General Assembly condemned this in a resolution, but this resolution condemning the violation of international law was adopted with the votes of only little more than half of the states, 100 votes in favor, 11 votes against, and 58 abstentions. So I think it is a dubious value of this resolution with such a low approval, although it was a, for me, pretty obvious violation of a key principle of international law. On the other side, we have activities by the United States, targeted killing, 2 famous incidents in 2019, killing of al-Baghdadi and of the Irani general of the special forces, Qasem Soleimani. These were not covered, in my opinion, by international law, but nothing happened after that. And we also have the practice of so-called humanitarian reprisals by Western states, also France, in Syria, which sanctioned the use of poisonous gas. There have been at least 40 incidents of use of poisonous gas in the Syrian civil war so far. I've been speaking about the institutions of international law and the criticism voiced against these institutions. And one particularly I find pernicious practice is the use of international organizations as scapegoats. I can give you a very nice example from the pandemic now. The World Health Organization issued a report on Italy's first response to COVID and mentioned Italy's failure to update the pandemic preparedness plan. This report of the WHO was removed from the website of the WHO one day after the publication. So everybody scolded the WHO of being politicized, etc. Who was it? It was the WHO Assistant Director, Dr. Ranieri Guerra. He's an Italian national. He had been responsible for the pandemic preparation in Italy from 2014 to 2019. Of course, the Assistant Director is obliged to loyalty only to the WHO, which he is serving now. However, his past role as an Italian civil servant, of course, gives rise to a conflict of interest. And this might have motivated the move to remove the report. This now looks like self-censorship of the WHO. And this is particularly problematic because Italy had donated $10 million to the WHO shortly before the publication of this report. I think that this episode illustrates all the structural handicaps which international organizations have. They are dependent on the member states with regard to the legal powers they have, with regard to the staff they have, and with regard to the budget they have. And the public underfunding then leads to a dependency on private funding, Melinda and Bill Gates Foundation. This risks creating additional problems, for example, lacking accountability and also conflict of interest, for example, with the pharmaceutical sector. Against this background, the scapegoating of international organizations is totally misguided, just like the warnings against a rising Chinese influence on the WHO. We know that the European states and the United States have long secured themselves disproportionate influence on other international organizations, starting with the UN Security Council, of course, over the World Bank and the International Monetary Fund, to name only a few. So rather than scapegoating, states would have to consider to increasing the organization's funding and so on. But, and also, yeah, lots of problems. I want to point out one final issue, which also became quite visible during the pandemic now, namely the issue of fragmentation and of so-called hegemonial regimes. Some regimes of international law are stronger than others because they contain more detailed rules and are equipped with a court or tribunal. For example, trade and investment law is stronger. And it has therefore been said that these regimes are hegemonial and risk of marginalizing the underdog regimes. For example, World Health Law is fairly weak. And we can see if we read the international health regulations that they are on the one hand unusual because they are binding and not only recommendations. However, they give to the WHO, to the Director General, they give him only the power to issue recommendations and there are no sanctions for non-compliance. And they also take into account trade and traffic right from the beginning on. For example, the Director General did not recommend border closures because he is, under the health regulations, obliged to take into account the problems for international traffic right from the beginning on. And therefore, he was very cautious in doing that. So we can see that the concerns of trade liberalization of movement of goods and people were from the beginning on, or are from the beginning on, inscribed in the World Health rules. On the other hand, when states wanted to restrict the movements of persons and goods, they could rely on treaty exceptions in the GATT, for example, and in the EU treaty. So I think this is a nice example of a mutual harmonization, one could say, of the various regimes. And I also think that the concerns, health concerns, for example, have not been subdued by the concerns for free traffic, because the member states didn't follow the recommendations of the Director General. So I think that the issue of hegemonic regimes and of fragmentation, it has been overstated, and that this example, the recent example, shows that it's actually not such a big problem as it used to be said. But let's now, I want to say some words more about having, well, let me just see. Maybe we can speak about the critique against human rights and the response to that critique in the discussion. And I would now just go in the final part of my talk to the big challenge which looms over all, and which is also the motto of this masterclass, namely the question, is it only a Western international law that now urgently needs to be adapted to the new economic situation, to the new ideational situation, and to the new power constellation, or will it fall if it doesn't succeed? So this is the problem of Eurocentrism of international law. And as we all know, international law was in a way invented in Europe and then spread to the world, but of course with brutal force, but not only with brutal force, also through appropriation. For example, states like China took and used the principle of sovereignty to argue against the unequal treaties which were imposed on this state. In the Handbook on the History of International Law, we specifically asked all the authors from the various regions of the world to look for institutions of international law from their region, which worked and which maybe also made their way into the body of international law. And the authors unfortunately did not find a lot, but there is now other research going on describing and analyzing systems of international law in other regions of the world before the European powers came, and besides the imposition of European schemes. The challenge that we only have a European system of international law hurts itself at the claim of international law to be universal. The challenge is, or the critique is, that it is a kind of legal imperialism which has been ongoing and which is still ongoing. I give you two recent examples: the practice of whale hunting, practiced by Japan and by indigenous groups. That's very conflictual. Japan relies on the whaling culture, ostensible whaling culture. Well, there is a whaling culture in some regions of Japan. The International Court of Justice found Japan to be in breach of the Convention on Whaling. And after this judgment, Japan walked out of the regime. So the result of the International Court judgment was that Japan is not bound by the treaty at all. Another example concerning the Convention on International Trade in Endangered Species. You know, there is a moratorium on ivory hunting, on elephant killing and ivory sales. In a recent conference of the parties, Botswana said that, well, the opposition against ivory is might be construed as racist. So what about these reproaches of cultural and legal imperialism and even racism? I think we should discuss these in detail in our Q&A. And I saw that a question was already asked whether there is any hope. So I want to conclude with some words on hope. First of all, concerning the analysis of the legal landscape, what's going on now, the examples I mentioned, of course, you can say the glass is half full or the glass is half empty. There is clearly a consolidation on a quite high level. It's true that there is less treaty-making activity going on, much less than in the 1990s, that there is a treaty fatigue, but there is nothing at all. For example, we have recently came into force the treaty on the prohibition of nuclear weapons. And we also have some movement in international organizations, for example, the voting reforms in the International Monetary Fund. Another point is, I just mentioned it, that the critique against international law and its institutions is hypocritical and self-serving, because it only comes once the regime really starts functioning. And the denunciations are pretextual. For example, the Philippines denounced the ICC statute when the ICC started investigating against its former president. So this tells us that the institutions are maybe weaker than we thought. When they start to work, then the states try to get out of it, and there is no way to prevent them from doing that. There is also movement in the sense that it's not only backlash and critique, but for example, important proceedings have been instituted. For example, the case now pending at the International Court of Justice because of genocide in Myanmar, instituted by the Gambia. So it's the Gambia, not a Western state. And that's, of course, a very important proceeding. Other important political events are also being dealt with by the ICJ, for example, the relocation of the US Embassy. So all that, there is ongoing activity. Also, the Security Council issued an important resolution with regard to the pandemic and saying that COVID is likely to endanger peace and security. So far about the analysis, what we see is a mixed picture. Now, what can we do, or which strategies should we espouse? I think that I only want to give you some important keywords now. One important point is multi-perspectivism, that we have to learn more, and by we, I'm now saying myself and the audience or scholars in, simplistically speaking, the Western world, we have to try to see the international world and international law more through the eyes of others from the other side of the globe. And I think that this is possible to try to practice this kind of multi-perspectivism and try to realize that, or always be conscious that everybody speaks from some standpoint, and that this standpoint has to be made visible and that you have to take note of it instead of making it invisible. I give you one example. For example, I'm a vegan, at least part-time vegan. So we have a word for veganism. But why do we have a special word for veganism? We don't have a special word for the practice of meat eating. We should call this carnism, to make clear that this is also a standpoint and that it is also an ideology and not just a neutral practice. And same thing, we should do this with the European perspective, Asian perspective, and so on. And we should also acknowledge more contributions coming from outside of Europe and try to seek an overlapping consensus on some principles, to use the word by John Rawls. We should also stop the practice of double standards, criticizing violations of international law elsewhere, while at the same time violating core principles, for example, with targeted killing and so on. I think that we should finally always take into account the necessity and the positive value of cultural pluralism without, however, essentializing this. For example, speaking of Asian values is also a kind of Orientalism, a reverse Orientalism, huh? Or speaking of the West is also, of course, an essentialism. The United States of America have lots of special outlooks which differ from Europeans. Lack of social security, lack of health insurance is only one example, which we see now. And final point, the aspiration to a universalization of international law must always be done bottom up, not as a top-down process. We have to ask the people on the ground what they think and what they want, not the elites who benefit. Don't ask the men who prohibit the women from driving a car but ask the women whether they want to drive a car. And there is an interesting empirical research going on. For example, a big project called the Word Values Survey, which systematically over many years now has polled people in all over the world and asked them, what do they think about family? What do they think about the environment? What are their beliefs? And such empirical research can also track changes in the beliefs. So speaking of beliefs, I think in the end, international law is, of course, a belief system. It is an intellectual and cultural construction, and it is based on the power of ideas. To quote Victor Hugo, who wrote, on résiste à l'invasion des armées, on ne résiste pas à l'invasion des idées.
Thank you. Thank you very much, Anne, for this big fresco of the current contemporary challenges that we are living in international law and generally in the world of today, I think. Many of the issues raised, double standards, human rights, the problem with international tribunals, the issue with international organizations, I really are at the core also of our masterclass generally beyond the West and the rest. And the idea of overcoming the European system of international law is really part of the big challenge we have to take. Also as scholars, as students, try to move beyond the West and the rest. So thank you very much. And I would like to give the floor to the first interventions we have, and of course, give to everybody the possibility to intervene in the discussion. Please use the Q&A, raise your hand if you would like, as we would really encourage you to take the floor and the video camera on so that we see you. I know that there are a few questions that have already been thought and reflected on by our students, and we can collect perhaps. Who is the first? Trevor.
Yes. Good morning, Professor. First of all, I wanted to thank you for being here with us today and for speaking with us. It was incredibly enriching and illuminating. So my first question, I know that you talked about critiques of cultural and legal imperialism of the Western world. So my first question is, what are some lessons that can be learned from non-Western ideas of global constitutionalism, and how can they contribute to your idea of this bottom-up universalization of international law?
Thanks. I leave my microphone on now all the time, right?
We collect a couple of
questions. As you want, as you prefer.
I think we can collect at least a couple, and yes, maybe we give some time later on. Yes, please. Who is the second?
Thank you also, Professor, for such a good, interesting presentation. My question relates to the nationalism that seems to have been brought to the fore by COVID-19, even if it was evidently there beforehand, and the fragility of international law that it has exposed with the arbitrary border closures and the lack of vaccine cooperation and the events in the US, Hong Kong. And thinking about your comment, which Trevor also mentioned on the need for a bottom-up approach in international law, I was keen to hear your views on whether global constitutionalism still has an effective role or could have an effective role in restoring cooperation between the nation states.
Please, Anna, yeah.
Okay. Yeah, first concerning non-Western contributions to international law. I think this is a delicate question because there is, once you ask the question, there is also the response that we should avoid the we too movement, in the sense that okay, we also had some elements. This is then again considered to be problematic. I don't exactly understand why this is problematic, but I want to point that out. So I think that, for example, Latin America has made very important contributions in the field of human rights. For example, inventions like the right to truth, the right against enforced disappearance is directly born out of the Latin American experience and has now entered the body of universal law. Mm-hmm. China is now making a big issue out of the so-called Bandung principles and the 5 principles of peaceful coexistence. These were principles of the 1950s from the non-aligned movement. These principles, they are actually classical principles of international law, and they have specifically been called principles of coexistence. I think, in a way, they have been superseded by the Friendly Relations Declaration of 1970, which is about cooperation and not only coexistence. So I see that this increasing invocation of the Bandung principles, I see that as a kind of going back behind the 1970s. So I'm ambiguous. I think it's an ambiguous value. Then there is this important Chinese-Russian declaration of 2016 on principles of international law. Here, China and Russia repeat the classic principles: state sovereignty, state immunity, non-intervention. So in a way, it is the hyper-Westphalian, the Eastphalian type. So it's not innovative, but backward-looking, I think. And what I found most troubling is that this Chinese-Russian declaration does not mention human rights among the key principles, and goes even the Bandung principles did mention the Bandung. So no human rights in the Chinese-Russian Declaration of 2016. I have Japanese colleagues. They have studied a lot the issue of sovereignty, and they could tell us more about sovereignty-like Japanese principles with regard to islands in the sea and so on. That's quite interesting. So these are just some concrete examples. And to conclude that, I think the most important contribution which has been made, for example, by South Africa, Portugal, India, is the focus on social rights, which has now really become more important. The need for it has become so much more visible also in the pandemic. Also the indivisibility and unity, the interplay of so-called social rights and so-called political civil rights has become as visible as ever before. And I think that this is very much a contribution, for example, of the South African Constitutional Court, which also shows us that there is a very important interplay between international and domestic level. International law can only be as good as the national institutions which apply and enforce it, and it must also come, again, bottom up from the legal cultures which exist on the ground. And this leads me to Charlotte's question concerning the nationalist reflexes which came up in the pandemic. At the beginning, this was quite chaotic, and the instinct seemed to be closing the border. However, we should not only consider this as pure nationalism, because fighting a pandemic needs a strategy of territorial containment. I spoke to a veterinarian and she said, well, the first principle is stand still of the herd and contain it. And you see that not only nation states, but also territories and even cities try to contain themselves. So that's then not regionalism, but it's purely the fact that there is an infrastructure of the states which exist, or of a region or of a city, and this infrastructure can be used for this containment strategy. With regard to animals, the typical second step after the containment is to kill them all. That's not done with the humans. But for example, 21 million of minks have been killed because there was a mutual infection between humans and minks. Nobody cares about those. And I think that the second step of the pandemic now with the vaccination, this has been sometimes criticized as vaccine nationalism, that states tried to buy vaccines and some states bought or reserved for themselves a surplus, for example, Canada, I think. But on the other hand, there is also the wonderful initiative COVAX, the platform created by the WHO and private stakeholders and so on, to finance vaccination for all and reach a fair distribution. And I think that this is a very nice operationalization of the principle of solidarity, which manifests itself. But as always, the movement is not only in the one or the other direction, but there are contradictory trends at the same time.
Mm-hmm. Thanks, Anne. We have other questions from our students, but I would like also to give the floor to some of our attendees, participants in the audience. So I will read the question we have in the question NA, and I would also encourage you to introduce yourself. Maybe in the question, say, probably Professor Anne Peters is happy to know where you're from.
Yes, I am, of course.
So Francesco Cannone writes, thank you so much, Professor Peters, amazing lecture. I see that all the reasons for you arguing that global constitutionalism is under attack directly flow from the very nature of international law, so that maybe global constitutionalism is just an aspiration which cannot be concretely achieved, but through a proper global constitution, together with the United States of the world, question mark. And the second question is from Luis Barreto Javier. Do you think that the new presidency in the US will change anything?
Okay.
Oh, Francesco wants to speak. Francesco, yes, take the floor. Maybe it's nicer so that we see your face. Noemi, can you authorize Francesco kindly? Ah, here we go. Francesco? Can you switch on the camera and audio? We cannot hear you.
Can you hear me?
Yes.
Okay, it's better that you don't see me actually, but since you encouraged me to introduce myself, I just wanted to let Professor Peters and you also amazing organizers to know who I am. I am from Naples and I studied law at the University of Naples Federico II, namely international law with professors Jovan and Palombino. And I specialize in international human rights law at the University of Essex. I hope that the premise of my question was wrong, because I'm not really acquainted with the exact meaning of global constitutionalism, but I would still like to hear from Professor Peters, even if I was wrong in the premise about the suggestion I was trying to make. Thank you so much.
Thanks.
So should I answer directly, Francesco? So you asked about the need for a global constitutional document. Was that you? Because I think there were two and I now maybe mix you up.
Yes.
Okay. Yeah, I think that this will not work and need not work because a world constitution and a world state would be unmanageable and not would lead to chaos and totalitarianism. So it is both not workable and it is not desirable. A world constitution with a full-fledged world polity, because the counter principle of subsidiarity is important and necessary to help to resolve problems which always have to be resolved by starting with action on the ground, closer to the issues, and which cannot be, there cannot be a top-down one fit-for-all solution, but this is not a good answer. Let's start it the other way around. Of course, we have problems which are global in nature. The pandemic is a global issue. On the other hand, one central authority would never be able to manage and oversee everything. We have an organization like the WHO, which must inevitably work together with lots of local actors, national or local. So there has to be an interplay, and this interplay can be structured by some guiding principles, and subsidiarity is surely one very important principle, which says that if in doubt, you have to act locally and find local solutions. But if this is not possible, you have to move to the next level. And then the next level still has to do, may give guidelines, but the implementation can only be done by local agencies, officers, and so on. Now, concerning the documents which contain these, which should prescribe action and contain principles and so on, the current situation is that the international so-called constitutional law we see is surely not only on the international level, but it is dispersed also in the national law of states. And the constitutional law, which we see, if we want to call it like that, is in itself completely fragmented and distributed over the various levels. That is my diagnosis. And so it is better to speak of constitutional law as opposed to the constitution in one document. I think the United Nations Constitution, the United Nations Charter cannot fulfill the function of such a world constitution. And I think it's also not necessary for the reasons I gave before. We need this interplay. Also in other areas, take human rights protection. It's now very urgent to protect human rights against business actors, against corporate power. And the current move of the Human Rights Council is also to suggest a binding treaty, which will, however, only, in quotation marks, oblige the states to implement in their domestic law specific rules and so on. So again, it is a very, you could say it's a very modest and weak picture that international law inevitably has to work together with domestic law. And the same applies to what I would say are the constitutional issues and principles. I think that was not it was a long and wounded answer to your question, but maybe it helped a little bit. Now, concerning the second question, will the new presidency in the United States make a difference? Of course, I cannot predict that, but concerning the announcements, for example, going back to the Paris Agreement, refunding the World Health Organization, reconsidering military deployment, these announcements point to the fact that there will be a different approach to international law. And the fact that the Trump administration damaged so much international law, and if only by offering a pretext for authoritarian states to say, well, if they do it, we can also do it. It shows, it's just one more illustration of the fact that the power basis of law is incontournable, that international law depends for its reality on implementation and enforcement on the ground, not necessarily with hard sanctions and so on, but other mechanisms, but action in any case to make it real, because otherwise the law is only on paper. And in that sense, what happens in the United States is eminently important for international law, because after all, the United States are still a very big power, even if they are on decline now and are precipitating their own decline by their own idiotism and uneducation.
Thanks, Anne. Maybe we have some other questions from the students of the Master in Human Rights, Security and Development of the Lille Catholic University.
Yeah, first of all, I want to thank you, professors. It's very interesting. My question is the following. By taking into account the social and political diversity within the various countries, especially with a nation such as China, which is set to become the first power in the near future. Is it possible to conceive a global constitutionalism without the constitutionalist trinity, so the rule of law, democracy, and human rights? Thank you.
Margaret, maybe? Margaret, do you have a question as well, I guess, or no? No, okay, later.
Okay, the Trinity, rule of law, human rights, and democracy is a component of constitutionalism as conceived in 19th, 20th century in Europe, and then in a way transferred to the international level. So of course, it would be possible to speak of constitutionalism without these principles. Wittgenstein, the philosopher, rightly says that the meaning of a word is its use in the language. If we use the word differently, it will change its meaning. But there is also a pernicious strategy attached to that. If you know the novel Brave New World, where there is this fiction of a state in which all the words have been hijacked. For example, the war ministry was called Ministry of Peace, and the word free could only be used in the sense of the dog is free from fleas. So if you hijack the words and then do an opposite meaning, then then something else comes out. So if we say constitutionalism would be about the rights of the state, about order, and about anti-terrorism only, then we must also clearly say that this is a different constitutionalism and not the one we have been speaking before. And for analytic clarity, it would be better to use a different word. However, your point, or this problem of hijacking words or of just a change of usage also appears at a different point in the whole debate. The critiques of the idea of global constitutionalism have always and exactly said that using the word constitution or constitutionalism for the international level is from the outset on a misnomer, that this was already the wrong hijacking which took place in a prior stage. So then maybe they would say, well, now this all shows that this mislabeling has led to disillusion and chaos, and that it's good that it's over, maybe.
Let's hope no. Question and answer from the public. We have from the audience. We have Camille. Camille, do you want to switch on your camera, or we read your question? We read maybe before. The same for the others in line. So in one of the readings you suggested, it was said that constitutional principles and procedures should not be transplanted, but translated to fit into non-Western states. I wonder what you thought about this statement and how you think this would work in practice. And I would also pick Christiane. Christiane said, the failing of international law manifestly very blatantly in the Middle East, and more particularly in the Palestine-Israel problem. The double standard applied in its application has remained mostly unchallenged. How do you explain that?
Could you, the second question was about the failure of the Arab Spring?
No,
I didn't hear it properly.
Sorry, it's about the failure of international law, especially in the Palestine-Israel problem. And the double standard there.
Okay, so these are two different types of questions. Camilla's question on the translation, the necessary translation of principles. I think translation at two junctures, one could say. First, the translation when you move from the national level to the international level, and then the translation in order to adapt to different cultural, to accommodate different cultural roots. Both are important in our debate, I think. example of democracy. Speaking of democracy on the national level means in a more firmer and rigid conception that we have to have votes, politicians are elected, they have a time limit, and then they can be outvoted if they don't deliver. On the international level, democracy is actually being requested a lot by states which are now only on the rise. For example, China very often says we need democracy in international relations, but they mean something different. They mean equality of states and equal participation of states and inclusion. And I think that on the international level, democracy in the form of a world parliament, as I explained with regard to the question of Francesco, will not be feasible. So we need to look for proxies or substitutes. For example, participation of NGOs, hearings, notice and comment, transparency as a precondition for being able to criticize. And this is then, in a way, you could say a translation of this principle. Now, a translation in order to accommodate other cultural traditions, I used the word overlapping consensus. John Rawls had used that in a more technical and sophisticated way to say that maybe we can agree on outcomes, but justifying them in different ways. For example, there are roots in Chinese culture which also speak of the importance, for example, of having something to eat and having a roof over your head before being interested in exercising your right to vote. And there's apparently a Chinese saying in that direction which has that meaning. I cannot put it together from the top of my head now. And there is also the German poet Bertolt Brecht, who said, well, erst das Fressen, dann die Moral. First eating and then morals. So there are different traditions which come to the same conclusion, namely that you cannot exercise your political rights if you lack the basic necessities of life, and that therefore social rights have to be the basis and are very important also. Mm-hmm. Then now the question, the double standards in the Israel and Palestine conflict. I think that this conflict is very much hampered by the influence of the great powers, and notably by the influence of the United States, which will also always exercise or threaten to use its veto in the United Nations Security Council when something comes up against Israel. That is surely a big factor, a big problem, but not the only problem. I'm not an expert on that conflict, and I don't see exactly where the issue of double standards comes in here. I have mentioned the problem of double standards at many places in the talk, and I think it is an important issue because the rule of law, as a core principle of constitutionalism, of course, exactly demands that we treat like situations alike, that similar situations must receive the similar legal treatment, and if not, then this is blatantly unjust and goes at the core of the rule of law, and therefore also at the core of constitutionalism. So therefore, double standards are very bad, one could say, very pernicious. On the other hand, now this is important, this is something new. On the other hand, the reproach of double standards is often made too easily. That, for example, China and Russia constantly deplore double standards. But as I said at the beginning, China now, for example, said, oh, we now have the same thing in the US as we had in Hong Kong. But it's not the same thing. In Hong Kong, these were pro-democratic protesters who wanted democracy. And in the US Senate, there were people undermining the functioning of democracy. So the idea of comparing these situations and saying, oh, it's the same, that is wrong in that case. So you always have to look really in detail before saying double standards. Or take another example, President Putin of Russia justified the annexation of Crimea by pointing to Kosovo and said, okay, we had Kosovo, Kosovo was done, so now we can do the same with Crimea, but it's not the same because Kosovo is not now part of the United States and has not been annexed by the United States and because of various other factors. So double standards is a big, big issue, but you have to look at it carefully.
Thanks, Anne. We have other and a couple of questions from the audience, and then I think we can probably close the question and answers. I would invite Idris to take the floor because she would like to speak. Ah, wait, we have Armando from Lisbon that was also visiting researcher at the Max Planck. So of course we take his last question. So before we have Kenza Jennifer Quitonda say, after the pandemic of COVID, do you think there will be a big change about the international law? Will it become a less serving tool? Idris, do you want to take the floor? Can you speak? Because you said you would be available to speak. Maybe we have an issue. In the meantime, I read the question from Armando.
Yes, I can speak.
Oh, wonderful, Armando. Please go ahead then. And welcome. Very nice to hear from you.
I don't hear anything.
Me neither.
Idris, you can talk now. Idris?
Well, we heard Armando for a moment.
Nowhere. Hello?
Idris, yes, we hear you.
Okay, thank you. I said I'm Idris, and I'm very glad to hear you, to have you the whole day. My question is about the preemptive security right. The invention and the operability of this right has totally changed the forces, the balance force in international relation, and probably has an impact on the so-called global constitutionalism. And how can we entertain about this this concept in this view on the described view of global constitutionalism? I mean, how can we deal and discuss about the preemptive security right in this context of global constitutionalism? Thank you.
Thanks, Idris. Armando, did you manage to fix the micro? Since yours is the last question, we can collect the third question maybe. I see you. Just unmute, I think.
Can you hear me now?
Yes, wonderful. Mm-hmm.
Okay, perfect. I'm not sure if you can see me, but well, I'm relatively info excluded, so I'm sorry for this. But still, my question is relatively info included. One thing, thank you very much, Professor Peters, for your insightful lecture. My question refers actually to digitalization and the growing possibility of communication between peoples, persons from different peoples. Do you think that this may contribute to the building of common values and common aspirations between different peoples? Or do you think that it rather promotes misinformation and entangled communication, and therefore will produce more damage to this project of global constitutionalism?
Thank you very much for these three excellent questions. The first was, I think, from Kaiser, yes. Right?
Yes.
Whether the whether international law and global constitutionalism has taken further damage due to the pandemic now. Again, we are still in the middle of this, so it is not possible to make full predictions. I would say that so far the pandemic has not been a Grotian moment, a decisive turning point in international law, as for example, after wars and after severe economic crisis, simply because it has not been bad enough yet, I think. So what we see is that the crisis is a stress test for the functioning of international law. It puts not only us under stress, but also international law. And that tendencies which have existed before, both factual and legal ones, have been reinforced. But because these tendencies are contradictory, on the one hand, more nationalism, vaccine nationalism, on the other hand, more solidarity, on the one hand, more surveillance techniques, speaking of digitalization, on the other hand, more concern for social rights. So these trends are reinforced. They point in different directions. We don't have one mega trend, and we also don't have one turning point. What I think is, looking at the glass half full, is that the constitutional principle of solidarity, which has been existent in international law, but in a very vague and fluffy shape, and which has been a constant demand of the global South in the sense of technology transfer, customary law-based cooperation, even without contractual obligations, etc., etc. This has been put into practice with the COVAX thing as one example. I mean, only in this small field of health law. And I think that this is a nice, so to speak, pro-constitutional development. Now for the second question by Idris, I don't know exactly what you mean by preemptive security. Maybe you mean the so-called preemptive strikes, military strikes against non-state actors and against so-called rogue states and so on. So the question or the phenomenon that the right to national self-defense of states, which is enshrined in Article 51 of the UN Charter, that this right is constantly expanded and used also against non-state actors, against terror suspects, and against, for example, the suspicion that a state has built up nuclear weapons. I think you mean that. I hope you mean that, because that's the only thing I know. There is this tendency of expansion of self-defense, and I think that the law is indeed in a gray zone now. For example, the question whether it is lawful to use self-defense against a non-state attack, which has been much discussed with regard to Syria. This is controversial now, and the law is in a state of movement. If it moves in the direction of expanding self-defense, that would be a modification of the principles on the use of force. And use of force is, of course, a key principle of international law. You could say it's not so much linked to constitutionalism as inspired by domestic principles, but is genuinely international. And I can't really say what this would signify for global constitutional law. No, I'm sorry about that. But maybe we can follow that up in some other forum or so. Now, third, Armando, very good question on the influence of digitalization. Again, I'm not a prophet. I think that cosmopolitans have always put a lot of hope in new means of communication. And already Kant and his contemporaries said that, oh, now that we have newspapers, and oh, now that we have the telegraph, now that we have the internet, everything will become better because we can learn much more about the other side of the world and feel that we are one humanity, and we can scandalize ourselves and we can activate civil society. For example, there was the technique of using flyers and petitions through the English Parliament by Quakers and by all kinds of women organizations to protest against slave trade and so on. So the means of communications are important. Their power has maybe been overestimated through history. I think that now digitalization clearly contributes to migration. I think that in the sense that in former times, people somehow accepted that they were born somewhere in some social class as a peasant, and they did not question that fact. They did not aspire to become a noble or so. They just accepted it. same thing. People accepted that they were born in Africa and that they are living in a very modest scale, and they didn't know anything about not much. And now people see YouTube and they see all kinds of things on their phones, which creates, of course, also a distorted picture, and which contributes to the fact that they simply don't accept that they have been born on the wrong side of the globe, at the wrong place, and that they just don't understand. And I think that it's perfectly proper to say, well, why am I here and why am I not living there? And why do I have to live a miserable life? And why can't I live like people in the film shows live? So digitalization, media contribute to a feeling of a common humanity, which cuts in all kinds of directions. Huh? It also, as you say, now we have this phenomenon of fake news and of conspiracy theories. And I think that this, in the pandemic, again, an example how the pandemic exacerbated trends which existed before, because all these silly conspiracy theories which have come up in the pandemic are incredible. It's not new, but new stories have come up which are so idiotic that you just can hardly believe it. But the media contribute. I think that probably the regulation will come after. The regulation always lags behind. I mean, we now see moves by Twitter, Facebook, and so on, for example, to, I think Trump was now cut off his Twitter account, at least for some moment after Wednesday. And that generally also the social media, they are forced to regulate. They try first self-regulation, then the states exercise more pressure. Whether that's successful, will be successful or not, depends on who is the more powerful, who has the leverage. But with the abuses, then after the abuses follows the regulation. So far, we see that also with business and human rights. The regulation may be late, it may be weak, but something happens, and this is an ongoing process. So I can't tell the results now.
Well, we have time also in this afternoon to continue the conversation. We will have at 5 o'clock the double interview also with Professor Bussani, who will have his lecture at 2 o'clock. So we'll be all day reasoning about law, globalization, international law, comparative law, contemporary challenges to our system. So I really am immensely grateful to Professor Anne Peters for having been with us this morning, and to all of you for having participated and being so active with questions and comments during this discussion. And I say goodbye, because we will see each other later on. To Anne, we will see each other at 5 o'clock, and to all the others at 2. So the link for the webinar is the same. I'm sure there will be other questions that we will have time to answer and discuss later this afternoon. So thanks again.
Thank you very much. Merci beaucoup. Pour les questions, pour la discussion, les questions très pertinentes, très difficiles, et la discussion continue. Hein? Pas de réponse.
Okay, thanks again. Have a nice lunch break, and see you later.
The very right to be human is denied every day to hundreds of millions of people.
Dans ce temple des Nations Unies, nous sommes les gardiens d'un idéal. Nous sommes les gardiens d'une conscience. La lourde responsabilité et l'immense honneur qui sont les nôtres doivent nous conduire à donner la priorité au désarmement dans la paix.
We've got some difficult days ahead, but it really doesn't matter with me now, because I've been to the mountaintop.
Chaque génération, sans doute, se croit vouée à refaire le monde. La mienne sait pourtant qu'elle ne le refera pas. Mais sa tâche est peut-être plus grande. Elle consiste à empêcher que le monde se défasse.